Welcome to tonight's program on the Michigan Independent Citizens Redistricting Commission. My name is John Miller. I'm director of the Dow Journalism program here at the college, and I'd like to welcome all of you who are here with us on campus in Plaster Auditorium, as well as those who are watching on our live stream feed and those who are listening on Radio Free Hillsdale 101.7 FM. For the next 4 hours, don't worry, we only have the room for 90 minutes. We're going to talk about this redistricting commission. And here at Hillsdale College, we are one of the only schools in the country that requires students to take a course on the Constitution to graduate. So we talk a lot here about elections and voting and representation, and these questions animate a lot of what we do around here. So it makes sense we would also take an interest in this commission and what it means for our state. And we have a great lineup of speakers tonight. I'm going to introduce them in turn, starting with Stephen Markman and then our professors here, Kevin Slack and Joe Postel. We'll start with Stephen Markman, who is perhaps the best informed person on this question in the state. He is a professor of constitutional law here at Hillsdale College. He's taught here for 28 years. He earned his undergraduate degree from Duke, his JD from the University of Cincinnati. In 1999, he was appointed to the Michigan Supreme Court by Governor John Engler, and was subsequently reelected to the position. He served on that court for 22 years, including 2 as Chief Justice. Prior to serving on the court, he served as an Assistant U.S. Attorney General under President Ronald Reagan and as a U.S. Attorney under President George H.W. Bush and on the Michigan Court of Appeals. Please give it up for Stephen Markman.
Thank you, John. I appreciate any introduction of that sort. My last introduction when I was still on the Supreme Court was from a moderator who introduced me as one of the finest judges that money could buy. And I think he was trying to say something nice, but I'm not sure if it came across perfectly well. My wife, who was with me on the dais, was introduced as one of the finest ladies to walk the streets. And I think she was similarly perplexed by the introduction. So, John, thank you for the kind introduction. I would like to talk about the new Constitutional Commission on Redistricting in Michigan. It is going to be a commission that will, hopefully, from the perspective of its advocates, serve as an example across the union to other states, in the hope that they'll adopt some kind of similar commission, some kind of similar proposal to what we have in Michigan. So the success or the lack thereof of our commission in Michigan, I think, is going to be an important facet of whether this is going to be emulated by other states around the country. But to give you a little background, late last year, a report was issued by the School of Public Policy at the University of Michigan and presented to the new Independent Citizens Redistricting Commission that was established by a vote of the people in 2018 to become a new part of our state's constitution. This year marks the first year of this experiment in constructing new electoral districts for Congress and our state legislature to serve for the next decade as the foundation of Michigan's representative process. The commission is charged with the task of constructing the boundaries for each of these electoral districts, replacing in the process the legislature that had been in charge of this task since our statehood was first achieved in 1837. Anyone reviewing the history and debate of 3 years ago will see clearly that the purpose of the new constitutional amendment is to address 3 principal concerns. First, to curtail so-called gerrymandering, by which oddly shaped and squiggly districts are established to give one side or the other electoral advantage. Second, to minimize the sheer partisanship of the process. And third, to avoid self-dealing, in which interested legislators constructed districts that were most advantageous to themselves and least advantageous to their future competitors. To say the least, the new commission is somewhat odd and certainly a unique institution comprised of 13 members essentially drawn at random, picked out of a hat, more or less, 4 of whom are self-described Democrats, 4 self-described Republicans, and 5 self-described independents. This is an independent citizens commission designed to bring a sense of fresh air and energy to an increasingly stale and antiquated electoral districting process. Fair enough thus far, although personally I tend to prefer the kind of citizens for such a critical public responsibility whom we the people, you the people, have actually voted for, and for whom we can unvote if we dislike their performance. 4, and this is what must be understood most of all, but seems not to be in light of the scant attention given to the work of the Commission, these 13 haphazardly selected citizens are presently engaged in constructing the very building block of our system of representative self-government, the fundamental units from which those who are to represent us in our public institutions will be selected. Our members of Congress and our legislators in the State House and Senate will all be determined by votes cast by people joined and divided by these new districts, each of which will be more or less inclined toward a particular representative, a particular political party, and a particular sense of public priorities as a direct consequence of where these district boundaries are placed. Thus, it's clearly not a trivial matter, for the process by which we select our representatives is, of course, the starting point for all else that follows in our constitutional system, one that's given rise, in my judgment, to the freest, the most productive, the most stable, the most innovative and inventive, the most genuinely compassionate and fair-minded nation in the history of the world, an exceptional nation, a chosen nation. Now, it so happens that the author of the U of M report, which was prepared in consultant with the Secretary of State and thus becomes a quasi-official report, is understandably proud of his analysis and has asserted that it offers a new theory of representation. Those are his words, although nothing along these lines was heard during the debate over the commission 3 years ago. The emphasis then was voters, not politicians, a redistricting process shorn of gerrymandering, partisanship, and self-dealing, replacing in control politicians with citizens. Now instead the emphasis, as I've suggested, something a little bit different, a new theory of representation. And ultimately I've been persuaded that the report's author is correct in this assessment. The report indeed presents a new theory of representation, only that while it is new, it is also, in my judgment, a deeply misguided theory of representation. And from this concern, Hillsdale College, an institution whose scholars, as you know, are unusually focused upon such hoary concepts as democracy, representative institutions, self-government, and public accountability, as well as such anachronistic figures as Hamilton, Madison, and Jefferson. Hillsdale asked me earlier this year to review the U of M report and to prepare a responsive report on behalf of Hillsdale College. And I completed that task several months ago, and there are now competing analyses of the new constitutional provision and how it is likely to inform the work of the equally new commission. These are essentially David and Goliath reports on the part of two outstanding institutions of higher learning in our state, Hillsdale College and the University of Michigan, although only the latter report has been accorded what I've said is apparently official sanction by the Commission. Now, what is the essence of the dispute on the part of Hillsdale and the University of Michigan? At its core, it has to do with the fundamental nature of the representative process. By what relationship should our public officials be held accountable to the people? In the present context, this dispute is straightforward and distilled as follows. What under the new constitutional provision is meant by the phrase community of interest, which phrase describes the electoral building blocks of our future representative system of self-government in Michigan? Mightily important, as we can all agree, I'm sure. Hillsdale College argues that the community of interest should continue, as it has previously been in the law, to refer to genuine geographic communities based upon geographic boundaries, in particular those of our counties, cities, and townships. Hillsdale offers a number of specific arguments on behalf of their understanding. First, that this is exactly what has always and exclusively been meant by the phrase communities of interest in our redistricting law, specifically in the decisions of the highest court of our state, the Michigan Supreme Court. The phrase in the context of districting and redistricting has only referred to geographic communities, real communities, not metaphorical communities. Second, actual districting practices in Michigan, as well in almost every other state of which I'm aware, have always been predicated as well upon the boundaries of geographic communities. While, of course, the new constitutional provision was meant to alter the law in respects, the public debate in 2018 was focused principally upon alterations in terms of who was to be the redistricting decision maker, the legislature or the commission, and the latter prevailed by a healthy margin. And the expressed concerns with the status quo, as I've indicated, were focused again upon gerrymandering, partisanship, and self-dealing, not the geographic basis of electoral districts, not implementing a new theory of representation. Third, Hillsdale sees the virtue of retaining geographic districts as communities of interest is that every citizen is a part of such a community, unlike the communities of interest offered by U of M and the Secretary of State, in which citizens will effectively be pitted against each other in contending for preferred community of interest status. Michigan's counties, cities, and townships are genuine communities of interest to which all citizens belong equally and in which all share a common interest and concern. And significantly for the process, it is a community of interest whose definition, based upon geographic boundaries, requires no prolonged hearings or debates by the Commission, no expert consultations or statistical assessments, and no confirmation by a vote of the 13 commissioners. If the consultants to the Commission do not understand this, our citizens, I believe, instinctively and certainly and overwhelmingly understand that places such as Kent County, the city of Marquette, and Bloomfield Township constitute genuine communities of considerable interest for the people of our state and do not require a 7-6 vote from the Commission as vindication for this. And finally, as the Hillsdale report states, such communities, geographic communities of interest, are where people reside, they're where people sleep, where they play, relax, worship, and mix with their families, friends, and neighbors. They're where their children attend schools, make and play with friends, compete in sports, participate in extracurricular activities, and are educated and grow to maturity. They're where the people work, shop, dine, and participate in acts of charity. They're where their taxes are paid, their votes cast, and library books borrowed and returned, and they're where their police and firefighters and emergency responders serve and protect. In short, these communities of interest, from time immemorial, have been truly meaningful and definitive to every Michigander, for they define what we call home, and they signify to the rest of the world where we are from. By contrast, the U of M report defines communities of interest in a metaphorical fashion, as I've indicated, in terms of special interest and identity and affinity groups, in a manner in which the term has never before been defined in Michigan law or practice. This new theory of representation, this new theory of what should connect the representative to those he or she represents, would replace the individual citizen at the center of the democratic process with the interest group. It would substitute for the ideal of equal citizenship favored and disfavored voting blocks. It would enhance the role of race, ethnicity, and religion as the fundamental identifiers of the American people, and it seeks to build a new electoral and political foundation upon the judgments and calculations of experts rather than those of ordinary citizens. It is, in short, a theory of representation that is grounded in ideology and identity rather than in a commonly and equally shared citizenship. Rather than looking to the boundaries of Genesee County and the city of Alpena and the township of Novi as the fundamental building blocks of the representative process, the U of M report defines these constituent elements much differently. For sake of example and illustration, the report proposes as our new building blocks, and these are from its own words, communities of interest predicated not upon geographic boundaries, but predicated upon racial, ethnic, and religious identities, communities with common bonds, communities with a linkage to a set of public policy issues that are affected by legislation, communities with a shared vision of the future, communities concerned about environmental hazards, media markets, affinity groups among neighboring jurisdictions, invisible communities of interest, like-minded nearby communities, communities with shared identities, communities with things that bind the community together, communities based upon determinations as to how the community engages with the political process, communities concerned about governmental policies that are high priority, nearby areas whose inclusion would strengthen and weaken representation for the community of interest, public arts communities, immigrant communities, enterprise zone communities, and special tax assessment-based communities, all calculated on the basis of metrics that will reflect our clear measure of compliance with the new amendment. Communities of interest, states U of M, can pick up the texture of bonds and interest within a political jurisdiction, and they can capture the current patterns of community life, whatever all that means. Understand then that these and similar considerations are to replace the single and predominant and historic consideration that has always been relied upon by Michigan in constructing their electoral maps, actual geographic communities. And in listening to citizen testimony offered to the Commission over past weeks and months, this consideration remains for most Michigan citizens what is most important, just not to the academic experts and nonprofit consultants for whom literally the only consideration that cannot be considered in constructing a community of interest, the only prohibited consideration is the geographic community. Can there be a single citizen within Michigan with an allegiance to his NBC media market, or a sense of attachment to the local enterprise zone, or a bond with his special assessment tax district? Are these the type of communities of interest or electoral building blocks to which a free and independent and self-governing people would ever choose to rest the future of their democracy or to communicate as the defining feature of their relationship with their elected representatives? All of these factors are set forth in the report that I just listed, with virtually no explanation or analysis, and without reference to our state's constitutional history or traditional practices or judicial law, much less any explanation as to what requires a new theory of representation at this particular moment in our history. And the vagueness and the unclarity and the open-endedness of most of these concepts, things that bind the community together, is apparently a virtue from the perspective of the University of Michigan, for it allows the Commission and its experts and consultants to do pretty much anything they wish in reimagining our system of constitutional government. It is already a commission largely and uniquely devoid of checks and balances, and the breadth of new standards proposed by the University of Michigan for the community of interest is further empowering to this already unprecedentedly empowered commission. Apparently, the commission and its experts will imbue these empty vessels of language with whatever meanings and understandings it chooses in reimagining the relationship between the people and their representatives. And this bears no resemblance at all, I would respectfully suggest, to the rule of law to which the Commission, as with all public entities, must adhere. The rule of law is all about standards, the setting of rules, criteria, and procedures that are defined in advance of a substantive decision and applied in an equal and consistent manner. Standards lie at the core of the rule of law in its decision-making, yet there are no serious standards, no intelligible or practical standards underlying any of the university's various word salads in giving meaning to the community of interest. Of course, none of this complexity or convolution or unchecked discretion would be necessary if the report had viewed the Commission's responsibility as simply organizing Michigan's political map in a fair-minded, neutral, and nonpartisan manner, which is exactly what the people voted for in 2018. But of course, more obviously is required if this map is to be reconfigured in accord with some new theory of representation, one that shares no common understanding with the people of Michigan who ratified the measure. Common understanding has always been the standard by which we tried to give meaning to constitutional provisions in Michigan. What was the common understanding of the language of such provisions to the people of our state? Let me emphasize a couple further observations made by the Hillsdale College report, and I think it's available to you outside here. First, the report not only substitutes an immense array of interest, identity, and affinity considerations in place of geographic ones in formulating the community of interest, but it expressly asserts once again that geographic considerations are the only ones that cannot be taken into account in formulating a community of interest. That is, the community of interest can mean anything in U of M's perspective, from shared media markets to linkages to public policy issues affected by legislation to affinity groups of limitless sorts. But the single thing it absolutely cannot mean is what the term has always before signified: communities defined geographically, that is, by real communities. Communities to which most of the 10 million people of our state have a real and bona fide allegiance, not the made-up and concocted communities creatively devised by experts who are determined to redefine the historic American concept of political representation. Secondly, and perhaps significantly, the report proposes communities of interest predicated upon race, ethnicity, and religion. Almost without a doubt, the most divisive and polarizing possible basis upon which our people should be electorally arranged. The truly overarching question in this regard, one that the Michigan report neither asks nor answers: did the people of Michigan who ratified this amendment in 2018 share a common understanding that by its provisions, in the first time in our state's history, our Constitution would impose an affirmative obligation to take race, ethnicity, and religion into account in setting public policy, even though such an obligation in such categories appear nowhere within the new amendment? And did the people of Michigan who ratified this amendment also share a common understanding that by its provisions, the supreme law of our state would impose an affirmative obligation to reconfigure electoral districts on the basis of express calculations of race, ethnicity, and religion? And did the people of Michigan who ratified this amendment share a common understanding that by its provisions there would be a partial nullification and undermining of the precepts of Article 1, Section 2 of that Constitution, that no people shall be denied the equal protection of the laws, nor shall any person be denied the enjoyment of his civil or political rights to be discriminated against in the exercise on the basis of race, religion, race, color, or national origin? And did the people of Michigan who ratified the amendment share a common concern or common understanding that by its provisions, at the same time we were according advantage to some racial, ethnic, and religious groups, we would necessarily be imposing disadvantage upon other racial, ethnic, and religious groups in the zero-sum world of electoral redistricting? And finally, did the people of Michigan who ratified the amendment share a common understanding that by its provisions they would also be acting in a contrary manner with the precepts of Article 1, Section 26 of our Constitution, a constitutional initiative enacted in 2006 that forbade the state, including expressly and interestingly the University of Michigan, from discriminating against or granting preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the context of a broad number of public policy areas. And third, it should be clearly recognized that if the Commission eventually adopts the recommendations of the University of Michigan report and rejects those of Hillsdale, little will be left of its potential legacy of reform. There will not be an end to the things that prompted the constitutional amendment under the rubric of voters, not politicians. Rather, each of the deficiencies in the process that led to the reforms may be perpetrated or even worsened, but this time under the color and protection of camouflage. Consider first how much of the state media, such as the Detroit Free Press, hail the new commission process as an end to gerrymandering. Certainly there have been such abuses on the part of both Republicans and Democrats over the years, where each have been in control of the legislature and thus the redistricting process. But the principal deterrent to the worst abuses have been exactly the rules that long guided the redistricting process, in particular the obligation of the map makers to respect geographic boundaries. The so-called 8-pole standards, named after the state election director who crafted the present standards 40 years ago, required that wherever possible, district boundaries must be drawn to contain only whole counties, and that any crossing of county lines be minimized in number, and that even when county lines needed to be divided, as few city and township lines as possible should be shifted or divided. The result was election districts that were largely and overwhelmingly regularly shaped, in which what were then understood to be communities of interest, places in which people actually lived, were maintained intact. Consider, however, how communities of interest will be constructed where the dispositive considerations are identity categories, special interest groups, and cross-jurisdictional affinities and shared interest, especially where guided by a report that asserts that geographic communities can't be considered as communities of interest. The result will be far more districts that unnecessarily snake and squiggle and contort across the map in search of more people to include in districts and more people to exclude from the newly reoriented communities of interest. Consider, second, the expectation that the Commission will curtail partisan decision-making. While the removal of the process from the control of the legislature obviously moves in that direction, it does not move very far when you take into account that many of the racial, ethnic, and religious, and special interest and affinity and shared interest and legislation considerations that are urged by U of M can easily be employed to allow equivalent partisan and political advantages to be made, but surreptitiously and less obviously. Those, for example, who view the Commission as having a legal mandate to optimize the votes of racial, ethnic, and religious groups, or to merge affinity groups across jurisdictions who favor or disfavor particular legislation, or to enhance the influence of communities with a shared vision of the future, whatever that's understood to signify, not only misunderstand the commands of the law and Constitution, but are effectively engaged in partisan calculations every bit as much as the most partisan legislature, but again, undercover. And finally, consider the expectations that the Commission will end self-dealing by legislators, certainly by transferring redistricting responsibilities upon the Commission. There'll be some gain in removing the legislators from that process. But what about the self-dealing U of M urges upon the Commission? According to the university, there's virtually no limit as to what might serve as a community of interest, except that it cannot be what everyone views a real community of interest to be. Therefore, there are literally an unlimited number of competing aggregations of people in our state who can be treated as communities of interest to be accorded advantage by the Commission, while all other aggregations of people will enjoy no such thumbs on the scales, justice, and fair treatment. And as a result, and because there are no intelligible standards, as a result, racial, ethnic, and religious groups will be treated as communities of interest to be favored in the political process, and some will be treated as being disfavored in the process, and there'll be no standards for determining why some are treated in one way and some are treated in the other way, and which affinity groups deserve designation, and which don't deserve designation, again, will be subject to standard list decisions. There are simply no rules in the law for these and countless similar decisions the Commission will confront. To be sure, they'll no longer be self-dealing by the state senator or congressman, and that is all to the good in my view, but instead there will be newfound opportunities for the commissioners themselves to exercise their broadened discretion on basis of identity, on behalf of identity groups, special interest, and affinity categories to which they either belong or share a personal preference. The Commission has the opportunity either to separate or to unite, to separate our people as members of interest groups and identity categories, or to unite them as independent citizens entitled to an equal place in the electoral process. Furthermore, the Commission is positioned to influence similar amendments considered by other states which are now assessing the Michigan example. Hillsdale College presumes that in ratifying the present amendment, the people were doing exactly what was heralded at the time. They were establishing a redistricting process at whose core would be voters, not politicians, and not reimagining their democracy or experimenting with new theories of representation. Thank you. Thank you.
It occurs to me that my community of interest is the broadcast zone of Fox Sports Detroit. So thank you for those clarifying remarks, Justice Markman. Next up is Kevin Slack. He's a professor, associate professor of politics here at Hillsdale College. And Kevin, you have a bunch of degrees I didn't realize. He has an undergraduate degree in history from Indiana University, an MA in political science from UC Davis, an MA in political theory from the University of Dallas, and his PhD in politics from the University of Dallas. So you were a student for a long time, but we decided to let him teach here at Hillsdale College. He teaches Constitution, public policy, political philosophy. He's also the author of a book called Benjamin Franklin, Natural Right and the Art of Virtue. Give it up for Kevin Slack.
In 2018, Michigan voters approved a ballot referendum to transfer the duty of redistricting from the legislature to a citizens' independent redistricting commission because, seeing gerrymandered districts, they wanted to end absurdly drawn partisan boundaries that protected incumbents, particularly Republicans, and many Republican voters supported this from a sense of fairness. Gerrymandered districts crack, pack, or stack district populations, dividing traditional geographic communities for reasons of partisanship and interest. Section 13C of the amendment states, quote, "Districts shall reflect the state's diverse population and communities of interest," end quote. In interpreting what communities of interest are, the Commission should itself be cautious to avoid the charge of partisanship. To do so, it should look to what the voters intended by the phrase as well as legal precedent. They should ignore the University of Michigan's report, which seeks to subvert both. The UM report, which has been endorsed by the Secretary of State, places its own reinterpretation of communities of interest as one of its, quote, highest priorities for the upcoming redistricting. It also admits that while legal community of interest have existed for decades in Michigan, their own interpretation of it is new. It departs from longstanding precedent. The report seeks to redefine COIs so that it can influence the redistricting commission to make decisions unauthorized by either the amendment or legal precedent. The report reads, quote, "Information on Michigan's population, its local political jurisdictions, and voting patterns are relatively easy to compile and make available to the ICRC. The same is not true for communities of interest. There is no comprehensive definition of a COI beyond the words in the Constitution, and as a result, there is no compilation of information about the state's COIs," end quote. Thus, instead of relying on Michiganders' own idea of fairness, the UM report provides a list of categories of COIs compiled by supposed academic experts to direct the redistricting commission on how to proceed. The first problem with the UM report's definition of COIs is that instead of traditional geographic communities, what Michiganders generally seem to report as their own communities of interest, anything can be interpreted as a community of interest. Thus, the very ills of gerrymandering Michigan voters wanted to avoid will, in the long term, be exacerbated by the report's reinterpretation. Secondly, the UM reinterpretation of communities of interest in the amendment brings serious legal concerns. It violates longstanding precedent that has understood districts to be geographic communities aligned with counties, cities, and townships. The Michigan State Supreme Court has determined, quote, "The basic building blocks of the apportionment rules are the counties. The Senate and the House are to be organized into contiguous, single-member districts drawn on county lines," end quote. Moreover, it upholds, quote, "requirements that the county, city, and township lines be observed in redistricting and apportionment, and that election districts be compact, so long as they don't violate federal constitutional requirements." And there's good sense in this. The court has argued that, quote, "the historical practice of following county lines has always been simply a device for controlling gerrymandering, facilitating elections and preserving communities of interest," end quote. Nothing in the amendment establishing the Redistricting Commission overturns that precedent. Again, communities of interest only restates the common sense geographic boundaries that have long represented Michigan's diverse communities. Because COIs are not defined the way that the UM report interprets, the Redistricting Commission must look first to legal precedent. The second legal concern is that the UM report's own interpretation of COIs includes no limiting principle for a court's interpretation. According to the report, quote, "a community of interest is a group of individuals who share common bonds, economic, ethnic, cultural, etc. But what may communities of interest not include?" The UM report itself states, quote, "the concept of a COI is subjective, and in no state is it well defined," end quote. Thus, the purpose for injecting this artificial confusion is to replace the traditional geographic communities, where the Supreme Court has determined that county lines are the, quote, "building blocks of districts." The UM report posits that its own new list of communities are to be the, quote, "building blocks of the new districts." Yet the old building blocks were the communities themselves, which represented the interests of those in their geographic boundaries. Now UM wants to divide those districts by race, ethnicity, and religion and unify them with pockets of other COIs. While the UM report bills its building blocks as, quote, "historical communities," they explicitly appeal to the most divisive identities, including, quote, "racial communities, immigrant communities, and language communities." This is the new theory of representation that it forwards. Again, the UM interpretation of communities of interest, if adopted by the Redistricting Commission, would set a dangerous precedent, a state constitutional mandate for racial gerrymandering. But that language was never included in the ballot referendum because Michiganders would never have voted yes to racial gerrymandering, arguably the worst kind. What the voters wanted was normalization of district lines and an end to the gerrymandering that corrupted the vital principle of representation. Again, if the Redistricting Commission accepts the UM reinterpretation of communities of interest, it is implementing a racial interpretation that Michigan voters did not approve. Finally, there's a gulf between the language of the amendment, which says that COIs, quote, "do not include relationships with political parties," and the reality that all redistricting has partisan interests and outcomes. Michigan voters are not naive. They know that redistricting is fraught with partisanship, but they wanted redistricting to be less partisan. Yet reportedly 2 of the 5 so-called independent commissioners have strong ties to the Democrat Party or liberal causes. One so-called independent supported Bernie Sanders. Commissioners are randomly selected by the Secretary of State's office, which is run by Democrat Jocelyn Benson. Not only should the commissioners attempt to temper these interests, they should acknowledge that its decisions will establish precedent for the rest of the country. Secretary Benson herself voiced her hopes that Michigan set a national precedent, and we are already seeing COIs being presented as a central priority for redistricting at the federal level in both the House and in the Senate. The goal of the UM report is to represent Michiganders not as individuals or members of a community, but as tokens of identity politics. Its new interpretation of communities of interest focuses on dividing Americans by mutually exclusive identities of race and ethnicity. The Commission members must ask if more political division is really what Michigan and the country needs. Thank you.
Thanks, Kevin. Next up is Joe Postel, who is an associate professor of politics here at Hillsdale College. He earned his undergraduate degree in history, philosophy, and political science from Ashland University, and his MA and PhD in politics from the University of Dallas. He's written a book called Bureaucracy in America, The Administrative State's Challenge to Constitutional Democracy. And he's the co-author or co-editor of several other volumes. He teaches here at Hillsdale College on the Constitution, political parties, and elections. Before coming to Hillsdale, he was an associate professor of political science at the University of Colorado at Colorado Springs. Give it up for Joe Postel.
Thank you. Thank you all for being here, and thank you to the college for giving me the opportunity to speak tonight. Thanks also especially to Justice Markman for his work and his leadership on this critical issue. My role here tonight is to supplement what's already been said, and so I'll be brief. Redistricting battles are these ever-recurring partisan conflicts that tend to arouse public passions to an inordinate degree. It's easy in the midst of these battles to mistakenly focus on short-term and partisan calculations rather than long-term and principled considerations. So what I want to do in a short amount of time is to just take a step back and think about why geography matters in determining representation in the first place in this country, and what good it does us to consider geography and how we represent voters. Ultimately, I think our constitutional system rests fundamentally on the idea of geographic districts, and we risk jeopardizing that system if we start to think about communities of interest as separate from geography. As Justice Markman has noted, the University of Michigan report boasts that it is advocating for a new theory of representation, and that new theory of representation is contained in this phrase that's been discussed already, the communities of interest. If this is the case, again, it's not known what this phrase will mean, practically speaking, but if this is the case, that we are embracing a new theory of representation, before embarking on such a journey, we ought to understand the benefits associated with the constitutional theory of representation and why the Constitution's framers embraced it. That theory of representation can be summarized as follows. In the first place, representation is supposed to, in the famous words of Federalist Number 10, refine and enlarge the public views rather than purely reflect the public will. In this theory, our elected representatives should not blindly follow the will of the public, but should be capable of resisting public opinion when it would be dangerous to the public's long-term interests to blindly follow it. This new theory of representation, as far as I can tell, sees representation not as a way of refining the public's views, but a mechanism for reflecting their characteristics. It's a mirror theory of representation rather than a refining theory. The second purpose of representation, again, most notably advanced in James Madison's famous Federalist Number 10, is to promote a pluralism or a diversity of interests through an extended republic. In that famous essay, as is well known, Madison declared that the size of the republic would be a source of control on the power of factions. While factions might be able to win a majority over a small territory, in a large republic, each faction is counteracted by the other factions that prevail in other parts of the country. Now, although this was not fully understood by Madison himself when he wrote Federalist Number 10, the basic idea was implicit. Representation should be by geography to reflect the pluralism of interests that are rooted in geography. In other words, Madison envisioned representation as being, or as reflecting a community of interests spread across a large republic, rather than one single national and homogeneous people. Specific representatives coming from specific geographically grounded districts, reflecting the local interests and the local communities that they were supposed to serve, would be advocates of those interests. So paradoxically, the plan was to increase the number of interests and the conflicts among those interests in order to reduce conflict as a whole. So this system would encourage deliberation, it would encourage bargaining and compromise, because all of these distinct communities represented by distinct representatives would have to build majority coalitions capable of governing. In summary, the theory of representation for the founders was twofold. Representatives should be able to rise above the will of their constituents when that will was contrary to the public good, and they should be rooted geographically in those communities of interest so that they could advance those geographic interests throughout the extended republic. Now, this view of representation, which values the sanctity of geographic communities, has not fared well in an age of modern technology and innovation. And it's also been damaged significantly by government policies that have weakened local representation. As I think is well known by all of us, communities themselves have been eroded and weakened by developments rooted in modern technology and innovation. Not so long ago, Tip O'Neill famously quipped that all politics is local. No sensible observer of American politics today would agree. All politics has become national. Communities have lost their unique identities. Transportation brings people from different communities closer together, but it weakens attachments within communities. Social media connects us to people across the country and causes friction between neighbors of differing views. These technological changes, which have weakened geographic identities and geographic communities, have been exacerbated by reforms such as campaign finance laws that encourage outside influence in local elections. More money is spent by outside contributors than by citizens who are voting in these elections. The effects of these disruptions are before our eyes on a daily basis. They're all around us. Americans are increasingly divided along national partisan lines rather than regional geographic interests. Local interests exert comparatively little influence over elections these days, which tend to reflect national ideological commitments instead of geographic communities of interest. Members of Congress increasingly cater to national groups and outside funders rather than listening to community leaders and local citizens and advancing those interests. These political changes have revamped our political system over the last 30 years. Instead of directing our attention to Congress with its messy pluralism and multiplicity of interests, people increasingly think of the president as the sole national representative. People are more attached to their national party than their local community. This means that political conflict centers around presidential elections and is increasingly divisive and personalized. Any approach to drawing districts that represents communities of interest without rooting those communities in, well, communities, almost inevitably will exacerbate these trends. Congress will become increasingly irrelevant as geographic communities lose their integrity and autonomy. Politics will become increasingly nationalized, polarized, and centered on the bare majority represented by the occupant of the White House. Congress will go further down the path that it is already on, a mere rubber stamp for the president's prerogatives when the same party controls both branches, or a focal point of national resistance against the president's agenda in a state of divided government. In either scenario, actual geographic communities will be washed over by national politics and polarization. This is certainly not the future that our founders had in mind when they constructed the constitutional theory of representation, nor is it the future that most Americans want, and as has already been indicated, it's not the future that Michiganders voted for. Americans are increasingly disillusioned with national politics, distrustful of the national government, and alienated from their fellow residents in towns across America. Our founders knew that conflict in an extended republic would be inevitable. They also believed that conflict could be advantageous by protecting us from groupthink, from majority tyranny, and from faction. But the system they designed was not intended to nationalize politics, nor to erode our sense of place and community. Communities of interest should be represented. That's how people have always been represented in American politics. But communities of interest have to be rooted in communities, grounded in geographic places. The mere act of drawing congressional district lines cannot reverse these larger trends that have plagued American politics over the past generation. For better and for worse, Americans no longer identify as strongly with their geographic communities of interest. However, this is not an argument for abandoning the traditional understanding of communities of interest, but an argument for reinforcing and supporting that traditional understanding. If we're going to keep governing ourselves peacefully, resolving our differences through bargaining and compromise, accelerating these trends, pushing us further into a nationalized, partisan, and polarized people won't make it any easier. Instead, the strength of our union depends in large part on preserving geographic communities of interest as the basis for our representative system. Abandoning geography as a central feature in defining communities of interest will only accelerate the alarming pace with which Americans are dividing and denouncing each other. Sending members of Congress who speak for the communities they're supposed to serve, rather than the national ideological agendas of interest groups, will facilitate bargaining and mutual accommodation, that will enable all of these interests to live together harmoniously. Hopefully we can remember these lessons as we go about this ever-recurring task of drawing districts, and we can aim to preserve geographic communities rather than weaken them further. Thank you.
Thank you, Joe. And we're now able to take some of your questions. I think, do we have a microphone working the room? Yes, we do. So if you have questions, just raise your hand and we'll bring the mic to you. I'm going to start with a question for the whole panel, and or maybe one of you can answer it, which is a question about timeline. We're in October of 2021. A year from now, we're going to be in the thick of a congressional midterm election, an election for representatives here in Michigan, also governor, and more. This commission hasn't drawn its lines yet. Is there a moment by which it must draw them? When will we know? What is it doing to consider the Michigan report, the University of Michigan report, the Hillsdale report, and so on? What do we foresee over the next few months?
Well, there is a deadline. The legislation required the commission to circulate the maps that it had prepared several weeks ago. They missed that deadline. It's still not been completed. The process is supposed to be completed by the end of the year, at which point the new districts would take effect in the law, and they would control the elections in 2022. But we seem a long way from that, and one wonders whether there are any possible sanctions or how that situation is going to be dealt with. But I don't know what's happening right now in terms of the day-to-day deliberations of the commission, or when we're likely to see the maps that should have been here several weeks ago.
Who would like to stump our panel with a tough question? We have one over here, it looks like.
Hi, thank you all for coming out tonight. So I kind of just wanted to ask for a sec, considering that it's the politicians and the major political figures who benefit the most from, redistricting, even under this independent commission, and that they have a lot of say in, promoting or, rallying the people against certain constitutional amendments or movements. Is there any practical benefit that, we in this argument in a return to redistricting based upon geographic boundaries, are there any practical benefits that we can sell to our political leaders and figures to get them on our side of this argument? As otherwise, I would just probably foresee them all rallying their strength and their political capital against the initiative and using the institutions to ultimately defeat it.
Sure. I mean, this is maybe less a tangible benefit, but I think this sort of the thrust of my remarks was that we have an increasingly dysfunctional national political environment. Most people are really dissatisfied with that environment, and this will basically accelerate all of the trends that have produced that environment. So if you want a politics that looks different from the kind of politics we have today, this approach is actually going to give you more of the same rather than something different. So that's less a tangible benefit to offer, but more maybe a return to a more functional political system, which I do think there is a lot of desire, there's a significant desire for that. And I think that desire crosses a lot of partisan lines. So that would be what I would offer to people who are really interested in what our argument would offer.
I mean, I would just add to that and say there's something to be said for a sense of justice, and I think that's why so many people voted in favor of the amendment. When you look at gerrymandering, I think people have just an innate sense that there's something not fair about this. And so you can find people of both parties who can come together and say, what we want are more normalized, contiguous, compact districts. And so that's something where if you have competitive districts, that people will think it's fair even if they don't appreciate the outcome of the election.
Question here on the side.
Thank you for your addresses tonight. Mine is very basic. Since this is a commission, how is it held accountable to the voters?
Well, the commission is not accountable in traditional ways to the voters at all. It was intended not to be accountable in traditional ways. Again, these individuals who are performing an extraordinarily important function within our governmental system have never been subject to a vote. Not one of them, to the best of my knowledge, has secured a single vote from among the 10 million people of our state. They can't be removed, to the best of my knowledge, from office. They are going to be in control of this process for 10 years. For all I know, and I believe they are decent individuals, engaged citizens of the state of Michigan. They're trying to do a public service. They're trying to do what they presume to be their duty. But normally the way that we select individuals for functions this extraordinarily important for our system is to have the people, we the people, having some opportunity to communicate their thoughts about what kind of people should be representing them in this process. And that is the great missing element of this process. These individuals were literally chosen at random. I've never heard of a selection process that was so disengaged from any effort to try to give the people a responsible voice in their exercise of self-government. It's a remarkable institution, and I don't cast any aspersion upon the 13 members of the commission. Again, I think they're trying to do what they think is right. But the fact is, we don't have any selection process other than somebody reaching deep into a hat and picking out names at random. And it's just not the way that this kind of decision-making ought to be done. But in fairness, it's the way that this commission was structured from the very beginning. The people of the state who voted on this and supported the amendment in 2018 did presumably have an opportunity to read the language, and if they did, they didn't seem to be too hot and bothered by the procedure that we created in this amendment. So how do you hold them accountable? At this point, all you can do is use the bully pulpit in various ways, and Hillsdale, to its great credit, not to mine, but to Hillsdale's credit, they were the one who decided that they wanted to participate in this process. They have decided to use the bully pulpit, and that in part is what we're doing here this evening. And how much impact it's had, I don't know. It's a lot of this is what I've described as kind of inside the beltway issues and don't immediately capture the interest of ordinary citizens within our state. But when you have an initiative process, as we do in the state of Michigan, by which constitutional provisions can be placed directly on the ballot by a vote of the people without the involvement of the legislature and without the deliberation of that process, the people do have an obligation. People in the end get the government they deserve, and they do have the obligation to read the amendment and to understand from their own perspective what the strengths and weaknesses of those amendments are. I presume they did that in this case before voting in favor of the amendment, but you have to trust the people to do the right thing in this kind of direct representative process of constitutional initiatives.
Do another question? Yeah, back there.
Thank you. Does the federal Constitution say anything about who is to do the reapportioning? Does it reference that the state legislatures are to do that?
What does the Constitution say about who does reapportioning in the states? I bet one of these professors knows.
I mean, the authority rests with the state legislature. If you're looking for, article and clause, I'm sorry, I can't provide that for you right now.
Well, I've been told that the federal Constitution references the fact that the state legislatures are to reapportion. So if that's true, then my question becomes, all these independent commissions, whether in Michigan or in Iowa or wherever, if the state legislatures did not grant their authority to these commissions, are they even constitutional under the federal Constitution?
I don't recall if it specifies which part of the states are supposed to take on the responsibility of reapportionment. I don't recall if it necessitates the state legislatures doing that or whether it just specifies that the states do that. So that would be one question to look into.
I don't believe the federal Constitution is implicated here. I think the federal Constitution focuses upon states making these decisions, presumably on whatever basis they choose to make them. In our state, as with virtually every other state, that process has always involved state legislatures. Several years ago, Arizona and then the state of California enacted commissions, not necessarily altogether similar to our commission, but that was done. And I don't know that we would want the federal Constitution to be interfering with whatever processes we, the people of Michigan, selected to implement and facilitate our own redistricting processes. And if the people of Michigan want to do that by a commission placed in the Constitution, or they want to continue to allow the state legislature to make these decisions, it seems to me that nothing in those decisions implicates the more general commands of the federal Constitution.
More questions? We got one right down in front here.
I would like to thank the panel, of course, for all their great work tonight. I've enjoyed it very much. My question involves kind of two parts, but they're really related. How are they getting the information for making these districts? Is it census data? Are they interviewing people? Is it just the feelings of the committee and then the legislature, as said? And then secondarily, how they deal with influxes of new citizens and, God forbid, Ohioans if they were to go into certain districts. If I was in, say, a Dearborn Muslim district and I moved there and it was districted on the fact that I was, or that they were Muslim, excuse me, how would I be treated? Would the districts thing reflect me? Because when you move, you have to change geography. I don't become Muslim or Middle Eastern because I move somewhere else. So how are they addressing these problems in the committee? And then if there are problems at all, and what are they trying to find for the information to actually district?
I mean, from people that I've talked to about this, when it comes to particularly the southern counties, there's not much knowledge at all. So imagine opening up your telephone book and saying, oh, here's the Chamber of Commerce, or here's a particular church. I think one of the disingenuous parts of the report is the listing of, say, religion. And so you might find, say, the recognition of an Anglican church in a county somewhere, but is that really going to be used for the composition of a district? No. So I think really what's going on here is the attempt to use this, right, this phrase, communities of interest, so that you could come up with anything as the nuts and bolts for gerrymander.
We have a question back here. This is former State Representative Eric Leuthäuser.
Thank you, and I thank the panel. Spot on, and communities of interest, obviously the big functional problem with this proposal. There's another phrase that's in my view equally problematic. I'd like to know if you know about whether it's at work in our Michigan Commission or not, and that is the efficiency gap, this so-called notion that any votes over a 51-49 split are wasted, and so the goal is to have every district to be as close to 50-50 as possible. I think it's a horrible idea because of what the student just said about moving, and people want to self-select and be around people like themselves. But I don't know if the Michigan commission is playing around with this term, or if this term is gaining traction in Michigan or in the other states that you've studied, this notion of an efficiency gap. Thank you.
Yeah, I be happy to. I've been thinking about this question quite a bit. I think ultimately the long-term goal of people who are behind these efforts is to fundamentally attack the way in which representation works in this country. And the way it's described is we have a sort of first past the post system in which there's one member from a district. Whoever gets the most votes in that district wins all of the representation. So if you win 51 to 49, you get 100% of the representation, and the 49% gets 0. Now, that has, from the point of view of people who I think are behind these efforts, the possibility of distorting outcomes to where you can win, say, one party could win more votes statewide than the other party, but not win more of the districts than the other party. And so the goal to get around this problem is either you eliminate or abolish districts completely, which is obviously a difficult thing to accomplish, or you close the efficiency gap. And you do that in two ways, right? One is you get rid of all of the wasted votes that come from winning a district 60-40 when you only needed to win it 51 to 49. And then you reallocate those votes to places where you might actually be able to win if you put those votes over there. I take this then to be not really about, and I think that this is consistent with a lot of the things that have been said, I take these efforts not to really be about trying to represent communities of interest, but more about how to win national, entrenched partisan policy victories. And that, I think, as I've sort of reiterated here, I think that could be very damaging for our national politics, especially given the trajectory that we're on. So I think you're right to highlight that issue as something that needs more attention.
We have a question right in the middle here. Going to make it as hard as possible for these folks with the mics.
Thank you very much. I understand this commission was drawn up by ballot initiative. If you could just, particularly for Justice Markman, if you could explain what that is, what they're used for typically, and whether or not a ballot initiative would be effective in this case.
Well, the commission was adopted by a constitutional initiative which allowed the people to introduce a constitutional amendment, vote on that amendment, and ratify it, which they did, and the proposition thereby becomes a part of the Constitution. Of course, you could, I don't see anything in the Constitution that would prohibit a counter initiative, if that's what you're saying, if I'm understanding you correctly. I don't think that's likely to happen. We don't have much of a history of counter initiatives in the way that we do have the 18th and 21st Amendments to the United States Constitution having to do with prohibition, which pretty much follow that kind of sequence. The 21st Amendment basically undoing the 18th Amendment and canceling out prohibition. But I do think we're not going to see any rectifying or remedying constitutional proposal until the people really understand some aspects of the current amendment a little bit better than they perhaps do right now. I think if the average person in the state of Michigan were to read the University of Michigan report or read the critique in the Hillsdale report of the Michigan report, they would really gasp at the incongruity of the proposals of the University of Michigan with their own perception of what it was that they were voting for in 2018. I think it would be extraordinarily interesting if there was some kind of poll to get some sense of how the people perceive the kinds of things that the University of Michigan is proposing in facilitating their new theory of representation. I really think that you can walk across the streets of any community in this country, in this state, you can describe to them what the University of Michigan is proposing, and I think there will be gasps and disbelief that somehow they have contributed to placing in the Constitution such a utter transformation of our constitutional system. Not only the explicit consideration of race and ethnicity and religion, but the total derogation of everything that's traditionally guided this practice. Now, I don't know exactly to what extent the Commission is going to adopt or concur with the recommendations of the University of Michigan, but the fact that there is the involvement of the Secretary of State in that process really does confer upon its recommendations an aura of semi-legitimacy. And that's why so many of us are assuming that the Commission will at least give more than ordinary deference and respect to the proposals of U of M, as opposed to the proposals that, say, Hillsdale has. And we do have specific proposals. And if any of you have our report, and I know it's available here, I would urge you perhaps to start with the proposals and recommendations that we make at the end of the report, because they summarize pretty well what the concerns are of Hillsdale with the larger proposition under consideration here.
Another question. We got one right down in front here.
Thank you to the panelists. I have two questions, if I may. The first question, a lot of the work that I think all of the work that the Commission is doing is public record, and a lot of it is available online on their website. So I was looking at some of the proposed maps that they're considering, and I saw one map where a sliver of Hillsdale County was kind of sliced off and attached to some neighborhoods in Detroit. I think I saw another map where parts of Hillsdale were matched up with Lansing and Ann Arbor, and I can't fathom how one representative can represent neighborhoods in both Hillsdale County and Detroit, or both Hillsdale and Ann Arbor. So to me, this just looks like gerrymandering under another name. So my first question is, I'm just wondering if the word independent is a misnomer. Is old-fashioned gerrymandering more honest? I know we kind of squeal and cringe at the way gerrymandering has been used in recent decades, but isn't old-fashioned gerrymandering more honest? And what advice would you give to these quote-unquote independent commissioners to make sure their work is as independent as possible? The second question, and Dr. Postel was starting to get into this a little bit towards the end of his comments, does what's happening here in Michigan and what could possibly happen across the nation, I know the For the People Act is kind of stalled in Congress, but if it were enacted, it would require independent commissions like this one in Michigan in every state in the country. Does this constitute regime change? Dr. Postel was getting into what republicanism means, what representation means for the framers of the Constitution. This sounds wholly different. Is this a new regime altogether? What would the country look like? What would our politics look like were this to be adopted on a mass scale? Thank you.
Yeah, so I mean, I think the first question, about gerrymandering, I mean, I think there are a lot of myths about gerrymandering and its effect on American politics. Most people think that polarization and gerrymandering are somehow connected, or that gerrymandering is driving a lot of what's happening in our politics today. The better explanation for what's happening in our politics is that we are sorting ourselves into like-minded communities. So you would have to, in order to create sort of moderate representatives, you would have to gerrymander districts in order to put people who think differently back together, given the ways in which people have moved into places where people think like them. So, and it does lead to the second question, right? What would our national politics look when we go down this path? I think we've already seen it. I think we're catching glimpses of it already. It's every 4 years. This is the most important election of your lifetime. Scorched earth battles to win 51 to 49% majorities for one office that gets to make all of the decisions, bare majoritarianism, that kind of thing. So that isn't a recipe for compromise and deliberation and mutual accommodation. And so that's why I think it's really important to pause at a juncture like this and think about the future we want to have politically.
We have time for one more question. And this Young man here will ask it.
Thank you for each of your talks tonight. I thought they were very enlightening. Right now I'm taking American political thought, and we spent the past 3 weeks talking about the Anti-Federalists and their views on representation. And I'm just curious on how this new vision of representation would compare to traditional Anti-Federalist thought.
I'm sorry, I couldn't clearly hear that final presentation of the question. Could you just repeat that, please?
I'm just curious on how this new vision of representation would compare to Anti-Federalist visions of representation.
Okay.
I mean, I would say succinctly, when I think of the anti-federalist, I think of small republicanism, right? Citizen participation, stress on virtue. When I think about this form of representation, it really emerges in you always have interest groups that play an important role in American history, but this form of representation really emerges in the 1960s. Jean Kirkpatrick, who was a Democrat herself in 1974, talked about this new form of representation that you find in the Democrat Party as part of the McGovern Commission in 1972, where there are de facto racial quotas that will be included in representation among the delegates. The basic point in order to overthrow that kind of mid-century liberal colorblind view, which they viewed as dishonest, because America was systemically racist, what you needed to do was to represent explicitly certain gender and race groups. And you call those the new states, if you will, right? So this is the way we ought to understand the American electorate. And I think anti-federalists, they have a very different view of republicanism. And despite their differences with the Federalists on how large the regime would be, republicanism really was the common thread that ran through both sides of that disagreement. And so republicanism, not just as a kind of form, but literally as a kind of soul, where people participated very intimately in local politics. Fast forward to today, and what do we have? We literally have the Democrat candidates talking about doing away with the Electoral College, and we have Republicans in Michigan who are voting for Michigan to allocate its electors based on the popular vote. So in other words, to make Michigan irrelevant in national politics. That has nothing in common with republicanism at all.
Yeah, I wanted to just say one thing before we ended our evening together here, and that is I think that some of the people who've been most poorly treated by this process are the members of the commission themselves. Remember again, these are citizens who've been drawn randomly and placed on a commission. They knew they were signing up for an important responsibility, a critical role. They were aware of that. But I don't think they were aware that their job was going to go beyond establishing regularly shaped districts and diminishing partisanship and doing their best, doing their level best to create honest and fairly put together districts, and that their role would be expanded beyond that to assessing the future visions of communities across the state of Michigan, in trying to weigh those visions that were best and that ought to be rewarded with community of interest status, assessing legislative policies that do or don't bind us together, and again, trying to reward those communities and those affinity groups and special interests that favor certain policies. I just don't think these were the kinds of things that most of these commission members really expected they were signing up for. I don't know that they feel they have any particular sense beyond any other citizen of what are high priority public policies and how do we promote those high priority public policies by squiggling around districts and getting hundreds or thousands of people who all share a common interest in those high priority policies. And when I say squiggle around in squiggly districts, of course, that's a legal term that you may not be aware of, but it describes the kind of gerrymandering that we're talking about here. But I don't think that these commissioners really had any sense that they were signing up to be our philosopher kings, the purveyors of our new theory of representation. I just think that they're probably as shocked by what they're seeing in some of these proposals as I and perhaps some of you are. So I think we have to understand that the culprit here are not the members of the commission, it's the experts and the for-profit academicians and the individuals who really do have an ideological axe to grind and see this as one of those rare opportunities that, of course, should not be wasted. We should take full advantage of this opportunity by using it to transform our system of government, something we could never do by any ordinary representative process of government.
If you'd like a copy of Justice Markman's report and you're here in Plaster Auditorium, you can pick one up on the way out. If you're watching on our live stream or listening on Radio Free Hillsdale 101.7 FM, you can go to our website at hillsdale.edu and find it there. Also, a recording of this panel will be on the college website within the next 48 hours, so you guys can watch it again and again. Guys, I think we're going to go viral. Join me in thanking Justice Markman and Professors Slack and Postel, and thank you all for coming.